Hello, everyone. Welcome to the ABA section of Administrative Laws and Regulatory Practices webinar on Congressional Oversight of the Executive Branch. I'm Jillian Metzger, not Nick McQuaid, who you're looking at, I believe. But I am a professor at Columbia Law School, and I will be moderating today's panel. Congressional oversight of the executive branch, as we all know, can lead to high political drama, at least in times of divided government, when one house of Congress is in the hands of the party opposite the president. We've seen high-profile investigations with all recent administrations. Many of you will remember the investigations into the U.S. attorney firings or the intelligence leading to the Iraq War under President George W. Bush. Under President Obama, there was the Fast and Furious investigation and the Benghazi investigation involving the State Department, and even more with the Trump administration, which has been engaged in an ongoing battle over oversight with the House of Representatives since the Democratic Party took control of the House in January 2019. That has led to numerous lawsuits, including a couple currently before the Supreme Court, and a number of interesting legal questions that we will be discussing today. A note on logistics to start with. We will be beginning with presentations from the panelists. Then we'll have a little bit of intra-panel discussion, and then we will open it up for questions. You will see, if you look on the bottom, I think it's the bottom right of your screen, a Q&A tab. We will be using that for questions. Please feel free to send questions along while the webinar is going on, but we will be doing a Q&A session at the end. And before I turn to introducing the great panel that we have today, I want to take a few moments to urge you to join the ABA Ad Law and Regulatory Practice section if you are not already a member. If you are listening today, odds are your interests and professional practice involve issues of government and regulation at the federal or state level. Perhaps you are an executive branch lawyer, perhaps you work on the Hill. Our section members come from all those backgrounds. They also include federal and state judges, ALJs, partners and associates at major law firms, general counsel of major companies, and even some administrative law professors. As a member, you will get to meet and learn from and engage with the experts in the section during our numerous events over the year. Membership also gives you access to our multiple publications on cutting-edge issues of administrative law, free online CLE, and in particular steep discounts at our great fall conference on administrative law and spring administrative law conferences, and more. So I hope you will join. I also want to give a disclaimer that all of the views expressed on this panel are the views of the individuals expressing them, and the views of the individuals should not be construed to be the views of the American Bar Association or the Section on Administrative Law and Regulatory Practice. Okay, so with that, let me introduce now our panel members, to whom I'm really delighted they were willing to participate today. I'm going to introduce them in the order in which they are talking. First, there is Ashwin Phatak, who is an appellate counsel at the Constitutional Accountability Center. We apologize to Ashwin earlier, but you will see my name under his picture when he is talking, but that is actually Ashwin. This is our first webinar, so please bear with us. Before joining CAC, Ashwin was an attorney advisor at the Office of Legal Counsel at the U.S. Department of Justice and served as a law clerk for Judge Millett on the D.C. Circuit and Judge Martin on the 11th Circuit. Ashwin has been very deeply involved in, I think, all of the cases we're going to be talking about today. He filed amicus briefs in all of them, so is a real expert on our matter at hand. Next, we will be hearing from Nick McQuaid, who you are seeing there. Nick is a partner at Latham and Watkins, who is also co-chair of the firm's New York Litigation and Trial Department. Prior to joining Latham, Nick spent 4 years in the White House counsel's office during the Obama administration, including 2 years at Deputy White House Counsel, and in that time extensively was involved in investigations and dealt extensively with congressional committees on those investigations. Before that, Nick worked many years as an AUSA in the Southern District of New York and clerked for Judge Denise Cote of the Southern District and Judge Katzman of the Second Circuit. Third, we'll hear from Mark J. Rozell, who is the founding dean of the Schar School of Policy and Government at George Mason University. He also holds the Ruth D. and John T. Hazel Chair in Public Policy. He is the author or editor of nearly 30 books on various topics in U.S. government and politics. And in particular, for our purposes here, he is a leading expert on executive privilege and author of Executive Privilege, Presidential Power, Secrecy, and Accountability, the fourth edition of which will be available in a month from University of Kansas Press. Anne, is there a way that we could have Ashwin showing on the screen? Because Ashwin, I'm going to turn it over to you to start with Nazar's, but I am seeing Nick only.
As soon as he speaks, he should show.
Okay.
Great.
Okay.
Well, let me start speaking then. Thank you so much, Jillian, for that introduction, and thanks to the ABA for holding this really great panel. So I'm going to talk about the Mazars and Deutsche Bank cases. Those cases are currently before the Supreme Court. They were argued via a telephonic oral argument in May, and we expect the Supreme Court will do a decision in those cases by the end of this month, usually, or maybe the beginning of July. So we should be hearing the outcome of these cases very soon. And these are really important cases because they deal with the fundamental power of Congress to investigate, in particular to investigate this president, which is what is at issue in these cases, but more broadly, Congress's power to conduct investigations that are in furtherance of legitimate legislative purposes. And the basic legal backdrop that governs these cases is that the Congress has the power to conduct investigations and issue subpoenas in areas on which legislation can be had. That's the test that the Supreme Court has put forward for a long time, many decades now, and that's the test that should be applied in these cases. I know the slides are flipping around a little bit, but I think it's the next.
Sorry.
This is the one. I think this is the one. So let me just first talk about the actual factual background of these particular cases. So there are 3 different committee subpoenas that are at issue here. And these committee subpoenas are actually directed at various financial institutions, Mazars, Deutsche Bank, and Capital One, for certain financial records having to do with the president, his family, and his business interests. Notably, actually, none of these cases specifically have to do with his tax returns. I know the tax returns have been sort of a big political issue, but these cases, although they may deal with certain financial records that touch upon the president's taxes, they don't actually specifically deal with his tax returns. So there are 3 different committees that subpoena documents in this case. The first, as you can see on the slide, is the Oversight Committee. The House Oversight Committee subpoenaed documents from Mazars as part of an investigation into presidential conflicts of interest and financial disclosure laws. The background of that subpoena is basically that this president has somewhat, quite in fact, uniquely failed to disclose certain financial interests and has failed to put his assets and businesses into a blind trust or some other type of protective mechanism as other presidents have done. And so this sort of unprecedented arrangement led the Oversight Committee to conduct an investigation into his conflicts of interest. In addition, there was some evidence that he may have failed to disclose certain campaign-related financial arrangements, and that came to light about a year ago, a year or 2 ago. And so the Oversight Committee was looking into financial disclosures. And their legislative interest in that case, they say, is that they are looking into potential changes to the Ethics in Government Act and other legislation that might have to do with the president's financial disclosures and the president's conflicts of interest. Next, there is a subpoena from the House Financial Committee to both Deutsche Bank and Capital One. And that investigation has to do with banking practices and foreign money laundering. And in particular, the committee is looking into certain practices that have been fairly well publicized in the news having to do with Deutsche Bank, the president, and certain Russian interests. There have been a number of reports involving the president's Russian interests, and in addition, certain debts that he has with Deutsche Bank. So the Finance Committee has said that what they're doing is investigating these issues in order to determine whether there are any changes that should be made to the nation's banking laws in order to tighten the laws with regard to foreign money laundering and other questionable financial practices. Finally, the Intelligence Committee has a subpoena for certain of the president's financial records that's almost identical to the Finance Committee's subpoena. And they say that they're investigating foreign interference in our elections, in particular, the ability for foreign countries to have some kind of leverage over the president or his business interests, and any legislation that they might want to pass related to foreign control of our elections or the ability of our intelligence services to more carefully police those types of issues. So these subpoenas all are issued by the House committees to these financial institutions last spring, and the president sues in district court in DC and in the Southern District of New York, arguing that these subpoenas are unlawful because they don't pertain to a legitimate legislative purpose or are in some other way unlawful. And the district courts in both of those jurisdictions basically rule in favor of the House, saying that the subpoenas can go forward. The president appeals to the DC Circuit and the Second Circuit, and those courts agree with the district courts, and now the president has appealed to the Supreme Court, which agreed to hear the case. And it was supposed to hear the case in March. Obviously, the COVID-19 pandemic delayed that oral argument to May, where they did it telephonically, which was an interesting experience to even listen into. I can't imagine what it was like for the justices and advocates, but it actually went pretty well, I think, by all accounts. And we are awaiting a decision. So I'll just say a couple points about these cases, because I think they raise some interesting broader questions about the scope of Congress's authority to conduct investigations. The first is this isn't the first time that Congress has conducted an investigation, as you might imagine, and in particular that it is certainly not the first time that Congress has conducted an investigation pertaining to the president, even pertaining to the president's financial record. So congressional investigations go back really far to the very beginning of the Republic. There's an example during the Washington administration, which may be the first investigation that Congress conducted of them investigating a particular military defeat in the Northwest Territory, and President Washington actually cooperated with that investigation, ended up turning over a number of documents to the committee. The Congress investigated President Jackson during his administration, and that case dealt with a fraud investigation and Congress specifically looked into potential presidential wrongdoing and President Jackson's connection to that alleged fraud, and looked at a number of documents, including letters that were sent between the president and his close advisors in the executive branch. More recently, obviously, there have been a lot of major investigations of presidents. Watergate obviously comes to mind, but I think actually a better example, more closely aligned with this one, might be the Whitewater investigation during the Clinton administration, when Congress actually looked at a lot of financial documents having to do with the Clintons, everything from Hillary Clinton's records at her law firm to the Clintons' tax returns going back several decades and other accounting documents. So I think it's worth noting that there is quite a long history of Congress conducting these types of investigations. And from my perspective, I obviously have a particular perspective in this case. I filed briefs on behalf, amicus briefs supporting the House of Representatives. But I do think it would be quite a sea change if the court sort of says, full stop, that these subpoenas are not permitted, that there's just no permissible legislative basis here for any of these subpoenas. There really have been a number of congressional investigations that aren't too different from this. And it would, the court would basically have to say that many of those investigations were unlawful too. It may do so. It's hard to know exactly. I think the oral argument was a little tough to read on this case in particular, but I do think it would be quite a change. Another important aspect of these cases, I think, is the scope of investigations and how broad a particular legislative purpose and investigatory purpose can be. So the Supreme Court has in a number of cases over the past few decades suggested that the scope of congressional investigatory power is quite broad, that it extends as far as legislation that can be passed by Congress. And so it seems, pretty clear that Congress has put forward a number of different plausible legislative purposes for these subpoenas. I think the question for the court is going to be kind of how far can you go with that? And I actually think it's worth thinking about the different committees' subpoenas differently. I think on the one hand, you kind of have the Oversight Committee and the Intelligence Committee, which really are focused on this president's financial entanglements, this president's possible conflicts of interest, and the possibility that foreign governments might have some leverage over him or his businesses, and the possibility that he may not have disclosed everything that he was supposed to on his financial disclosure forms. And, knowing some of the president's financial records in order to have a better understanding of what happened with regard to those issues, I think is pretty closely tied to that legislative purpose. It's almost hard to know how Congress could investigate those things without looking at those issues. On the other hand, you have the Finance Committee's investigation, which is looking a little bit more broadly into the nation's banking laws, into possible legislation on foreign money laundering and other types of banking practices. And I still think that this president could potentially offer a valuable case study on those issues. Certainly, the reporting has suggested that his connections to Deutsche Bank and other banking institutions, as well as his possible properties and other business interests in Russia and other places might be problematic. But definitely the argument seems like a little bit more of a case study, like this is a really good example of something broader that they're looking at. And so, that obviously pushes the doctrine a little bit further. I don't think it's too different from other investigations that Congress has done, but I do think there's a world in which the court kind of looks at these different committees a little bit differently, the subpoenas from these different committees a little bit differently. The final thing that I bring up is that, I think the key argument that that President Trump has offered in response to these subpoenas is that the committees are basically engaging in law enforcement, that they aren't engaging in a legitimate legislative inquiry. And they make the argument basically that even if Congress could come up with some legislation that could be had in these areas and could somehow connect these subpoenas, the relevance of these subpoenas to those particular inquiries, the argument would be that what they're really doing is some kind of law enforcement. They're kind of targeting the president and seeing whether or not he violated the law, whether it comes to financial disclosures or money laundering or other foreign entanglements. And they want to know whether or not he broke the law. And for that reason, they're unlawful because Congress can't engage in that kind of law enforcement type of investigation. They can only engage in legislative investigations. That argument has been rejected by the court a few different times now. It's sort of come up in different contexts, and the court has been pretty clear that you're not supposed to kind of go behind the veil and look at what particular legislators are thinking when they issue these subpoenas, as long as there is a legitimate interest that they can point to. And I think there are a whole bunch in this case that they can and have pointed to. Actually, they've literally pointed to specific legislation that they're considering, whether it's amendments to the Ethics in Government Act or a bill called HR 1, which deals with all kinds of conflicts of interest having to do with the president and other federal officers and foreign interference and entanglements. So, they've really offered a whole lot of legislative purposes, but I think it'll be important to see whether or not the court accepts this law enforcement argument, which I think would narrow Congress's powers in a lot of ways when it comes to looking at wrongdoing. I mean, you can imagine Congress looking at all kinds of criminal or civil laws and penalties and wanting to kind of look at particular actors they think are violating these laws or just kind of touching the line when it comes to these laws in order to know how to strengthen them. And so I think it has the possibility of limiting Congress's powers in those ways, but I think that would be an important thing to look for in the court's decisions. I'll just mention one more thing about this case. I know my time is almost done, but The final point I'll mention is that there was an interesting order from the Supreme Court that came out, which asked the parties to brief another issue just before the oral arguments, having to do with whether or not this case is justiciable at all. And it seemed to have the flavor of kind of a political question doctrine argument. So basically, this doctrine says that where a legal issue comes to the Supreme Court that is not really administrable by courts at all, or seems to be in some way left to the other two branches, the executive and legislative branches by the Constitution, the Supreme Court or other courts shouldn't wade into that issue. They aren't equipped to wade into it. This was kind of an interesting order that came down. I don't think a lot of people knew exactly what to make of it. It's odd because the court has actually adjudicated a number of disputes between the Congress and the executive branch when it comes to subpoenas and other congressional investigations. So it would seem that if they said that all of those types of disputes are actually political questions that can't be judged by the courts, they would have to overrule some other decisions. And I think it was noteworthy that all of the parties agreed that it's not a political question, that the court should just apply its case law about when Congress can issue subpoenas and decide these cases. And it didn't really come up at oral argument much. I think it might have come up in one question. So it didn't really have a very prominent place in the oral argument. So I'd be surprised if that's the way the court goes, but I think that's an important flag. And it obviously relates to the McGann case as well, that issue of justiciability and when the courts can decide these types of issues, which I think is the next case that we're talking about. So I think I'll leave it there. And if folks have questions during the Q&A, I'm happy to dive into other parts of the case or anything else you might have.
Great, thank you very much. Nick, I think the slides are up. You want to talk about McCann?
I can see them.
Right.
Thanks so much, Jillian and Ashwin. Thanks so much. That was a great segue. So I'm going to talk about House v. McGann, which is currently pending in front of the DC Circuit en banc following oral argument in late April. I thought I'd start by just kind of going through the facts of the case, and there is on McGann. The central facts here are as follows. McGann was a central figure in events that were first investigated by Mueller and he's a central figure in the Mueller report. As the action of investigation started to focus more on the Congress, he was the subject of a subpoena, first for documents and then for testimony from the House Judiciary Committee as part of its impeachment investigation. He was instructed by the White House counsel on behalf of President Trump not to testify and in front of House Judiciary despite a subpoena. And the focus of that instruction was a theory of and I should start at the beginning, of course, that these are my personal views, not Latham and Watkins, and not any of clients that I represent. I still do practice in this area. But McGann was was instructed to not testify by the White House, and the basis was the view by the Department of Justice that is long held that certain aides, close aides to the president, are immune from compulsory testimony by a congressional subpoena. And it's a view that's heavily based on separation of powers principles and has been employed by both parties. So that led to Judiciary Committee suing in August of 2019 to compel McGann's testimony. And that the case got wheeled out to Judge Ketanji Brown Jackson, and she issued an opinion in November of 2019. It was a quite lengthy opinion, incredibly detailed, that addressed kind of three principal areas of concern. The first was whether there was a cause of action to sue. The second was whether the case was justiciable, and as Ashwin referenced, I think tied into that are political questions, concerns, as well as standing. And then third, the question of whether testimonial immunity is a viable theory, and one that is supported, that is a basis to reject a subpoena for testimony. The upshot of her opinion was, one, that that there was a cause of action, two, that the case was justiciable, and then finally that she rejected the notion of absolute immunity, though she did make clear that there was the ability to invoke executive privilege on specific questions in the process of testifying. And I think just I'm going to stop for a second, just do a couple of points on her opinion that I think are worth noting. One is that I think it previews some of the concerns that were fairly prominent in the district court, in the DC Circuit opinion, was that she really addressed the parallels between this case and the Myers case. And there, the Myers case was the last time that this issue had been tested, the testimony immunity issue, as well as one of the more recent justiciability cases. And she pointed out that the facts here were very similar. Harriet Myers had been White House counsel. She rejected a congressional subpoena based on testimony immunity, and that DOJ in that case made all the same arguments that they were making in this case, and that Judge Bates in that case rejected those arguments, said that the court had the ability to resolve the case, and really, in that opinion, really, in the Myers opinion, really emphasized that despite the concerns that this was a unique situation where the court would be weighing in on a political inter-branch dispute, that actually this was just really a question of subpoena enforcement, and that's something that federal courts did all the time, and really was comfortable in that. It was a comfortable practice and something that the courts knew well how to do. And Judge Bates in that case rejected the idea of testimony immunity. It was obviously a district court opinion, not controlling on Judge Jackson, but she made clear that she found it persuasive and noted that how parallel it was. Don't know exactly what all went into the emphasis she put on it. Obviously, it was a prominent opinion. It may also have been notable that Judge Bates was a Republican-appointed judge who was weighing in on a Republican White House counsel, and kind of a early, emphasizing the parallels. I think emphasized that this was not a partisan issue, but more one of just of clear analysis of law. McGann appealed after Judge Jackson's opinion the next day, and the Court of Appeals stayed her ruling, and the case went up to the DC Circuit. If you can go to the next slide. So in late February of 2020, that a divided panel vacated Judge Jackson's opinion, and the majority opinion, which was by Judge Griffith, did not really take on the testimony immunity piece, but focused on justiciability. And his opinion was that this case was not justiciable based on separation of powers concerns. His focus was on what he called the quote was, focused on the inner branch nature of this, and effectively his view was this was not subpoena enforcement, but instead was asking the courts to weigh in on a branch between a dispute between two co-equal branches, and that wasn't the separation of powers cautioned against that kind of intrusion onto another interbranch dispute. He referenced it as an intramural dispute about the operations of government, he also expressed concern about the fact that in resolving this kind of dispute, that it was pulling the judiciary into what are really partisan disputes, and noted, the highly partisan nature of other disputes that had arisen between Congress and the executive branch over subpoena enforcement. He also suggested that there was, an appropriate mechanism for that dispute to be resolved, and that mechanism is the negotiation between the two branches, often referred to as the accommodations process, and that the two branches have a mechanism to resolve these disputes. Here, the Congress and the executive, without going to the courts. He also warned about a kind of rush of cases that could follow if the courts started to resolve these. I think that and pointed to historical practice to suggest that courts had hesitated to get involved in these cases or not been involved in these cases. Obviously, there's tension with that view and more recent history where there are a number of different opinions that have addressed these issues. But focus on the historical practice piece. Judge Henderson joined on the justiciability point, but also went on to fairly soundly reject the notion of testimonial immunity as being one that did not have support in case law, and instead, emphasized that it was really built on different opinions by the Department of Justice, and not there was no clear case holding that supported that testimonial immunity. And then Judge Rogers dissented. She went back to the notion of subpoena enforcement being a very traditional and commonplace function of the federal court, and also rejected the testimonial immunity. So that was then a petition for rehearing en banc, which was granted, and with the focus on the justiciability issue. As Ashwin noted, there's kind of an overlap here because that argument was held in late April, right after that was when right before that was when the Supreme Court asked for additional briefing on political question in the Mazars cases. I think that's it for the slides, Jillian, if you want to take those down. And the parties are currently waiting to hear from the court. I think that the oral argument was interesting. I think it's fair to say that it seemed from my read was that there was a fair degree of skepticism about an absolute statement that these cases were non-justiciable, but also a concern about limiting principles. It was held in, the case went up with the Mnuchin case on the spending power, and I think that also raised that was also part of the concerns that were raised about the limits of what are the limits of the judicial branch's role in disputes between the executive and congressional branches. Legislative branches. Just a couple of observations about this. The first is that from the kind of practice of congressional oversight perspective, from the kind of what it's like to be on the ground negotiating on behalf of the executive branch with the legislative branch, and I think vice versa, though I haven't done that role. I think the idea that these cases are non-justiciable would be just a massive sea change. It is absolutely a case that these cases have been rarely litigated, but litigation and positioning for potential litigation has done a lot to inform how parties approach this dispute, and I think has had a real role in shaping the accommodations process, which is the kind of negotiation that happens between the two branches, and there it has been on both sides, I think, a reluctance to take absolute positions without really being thoughtful, because it leaves you exposed if you go to court and you really just have said no, or just haven't been willing to kind of shape your requests. So kind of without the backdrop of litigation, I think it would really change the way the practice is done. I think a second point is that this is really monumental for this area of the law. There really have been quite few cases since the Watergate era when there were a bunch. And so whatever comes out of this series of cases, it will be a lot more of instruction and instruction at the Supreme Court level than has happened in a long time. And so this will be shaped by this period. And so I think it's very important in that regard. The last thing I will say is just as an executive branch practitioner is despite the fact that it gets routinely rejected by the courts in different instances, I'm actually, I'm very sympathetic to the testimonial immunity arguments. And I think that it is a, when you think about very senior White House officials, national security advisor, chief of staff, White House counsel, that an ability to compel them for testimony, even with the protections of executive privilege, does have a real impact on the independence of the branch. And that was really where the doctrine started. It's morphed a little more to being more about kind of using that immunity to protect executive privilege. But I am sympathetic to those concerns. So I think that's it, and maybe turn it over to Mark.
Great, thank you, Nick. Hang on, sorry.
Okay.
Nick, Mark, let me just get up the,
Yeah.
yep. That's
Yeah,
not
that's
working.
fine.
Hang
Take your time. That was a very nice segue, by the way, to
on.
executive privilege while you're doing that. I can say while you're pulling that up, executive privilege is a rather murky area of constitutional law. It has evolved over the course of our history. The common understanding of the scope and limits of that power have evolved and changed, I think, somewhat significantly over time. In my book on executive privilege, I've defined it as the right of the president and high-level White House officials to withhold information from Congress, the courts, and ultimately the public. So customarily, presidents will invoke executive privilege themselves, or they will direct members of their cabinet to do so. This is an implied Article 2 based power. And I've argued that no one other than the president himself has the ultimate authority to claim executive privilege.
Mark, can I just interrupt for a second? Are the
Sure,
slides
sure.
now up for you?
It's fine. I can see it. Yeah, I
Okay.
assume everybody else can too. Controversies over executive privilege go way back to the earliest years of the Republic. Interestingly, the phrase executive privilege was not a part of our common language until the 1950s, when President Eisenhower first invoked that language in defense of withholding information, withholding testimony. But some scholars have played word games. Raoul Berger wrote his famous book in the 1970s arguing that executive privilege is a constitutional myth because it is nowhere mentioned in the Constitution. But putting aside word games of that like, all presidents going back to George Washington have exercised at some point something analogous to what we would call executive privilege, something equivalent to the concept of executive privilege. And in fact, in the first presentation, our colleague was talking about the St. Clair incident, in which President Washington had pulled together his cabinet to discuss the very issue of whether a president has a right to withhold information, testimony from Congress and the like. And although the president had cooperated with Congress and turned over information, he had initially asserted the principle that when in the public interest, it is appropriate to withhold information. The president indeed has that power to do that. So that was a wonderful precedent for the exercise of executive privilege. So the fact that it is nowhere mentioned in the Constitution is of no matter at all. You can go to the next slide. Okay, so again, it's an implied power, and I agree with Nick, it is sometimes necessary to the proper functioning of the executive branch. Presidents and their staff have made the argument, I think with a great deal of validity, that they should be able to deliberate without fear that every utterance is made public, and that there is a public interest component to having a certain sphere of candor within the White House that should be protected. On the other hand, this is a balancing test when there are allegations of wrongdoing, for example. The claim to right of secrecy weakens substantially. So in a democratic republic, the presumption generally should be in favor of openness, although There are some cases in which the national interest is best served by secrecy. But it's important to point out, and our panelists know this from their experience, this is not an absolute power. Like other constitutional-based powers, it's subject to a balancing test. Go back to the Nixon case, for example, most famously, that articulated that principle that there is a legitimate power of executive privilege. But in that particular case, it had to weigh to the needs of a criminal investigation to get the information about the president's own complicity in the Watergate crisis scandal at that time. So there is a recognition that Congress must have access to information from the executive branch in order to carry out its investigative function. I would argue that the investigative function does not have to be related specifically to an area where legislation can be had. It can just be an investigation. And I would argue for a sort of broader reach for Congress's ability to get access to information in cases of investigations. Some administrations have tried to draw a distinction between Congress asking for information in cases of investigations as opposed to in cases of legislation, and made the argument that the case for executive privilege is weaker in the former. But I've argued quite contrary to that position. So again, any claim of privilege has to be weighed against Congress's legitimate needs and rights under our constitutional system. Okay, next one. One before that, okay. Obviously, not all presidents have exercised this power judiciously. Some have used it to cover up embarrassing or politically inconvenient information, if not outright wrongdoing. So we have seen a number of cases of abuse of this authority, which ultimately has given executive privilege a somewhat bad name. And I point that out because very interesting, when I was doing my research on the first edition of my book back in the early 1990s, I went to the various presidential libraries, looked at the internal documents. The immediate post-Watergate presidents, one after another, were advised by their advisors, legal counsel, do not use the phrase executive privilege. You do not want to be equated with the Nixonian abuse of power. Call it something else. Please don't call it executive privilege. That doesn't mean they didn't exercise some version of what we call today executive privilege, but the principle of executive privilege in name had been driven underground for quite a long time. And there were presidents who indeed were reluctant to even exercise that power, even if not in name. The one I hesitated about putting in this category was Obama, because he did use executive privilege, but I would not say that he did so excessively. Those who have misused it on occasion or more than on occasion, I've put in the category Nixon, Clinton, Bush II, and also President Trump. Okay, next. So there have been three major controversies over executive privilege in the Trump era. I think I can expand this. I completed a couple months ago the 4th edition of my book on executive privilege. The frustration of writing about this topic during this administration is whatever I settle on the day I send it to the publisher becomes quickly dated. As you can all imagine, there's just so much that's happened since I let the manuscript go. But anyway, the Russia investigation, a Mueller report, the citizenship question in the White House, security clearances investigation, and I'm not going to go into details. Just hit the key points here. I make the argument in the book that whereas past executive privilege controversies generally have occurred within a recognized framework of constitutional separation of powers issues, the Trump administration has applied this unusual concept of a protective executive privilege, sometimes calling it a prophylactic executive privilege, a principle that recognizes no countervailing or balancing of powers against those of the executive branch. It's an absolute unconstrained executive power that I argue has very broad implications beyond the principle of executive privilege itself, and sets a terrible precedent besides for the future exercise of executive privilege, effectively writing Congress out of the equation if you take it to the extreme. Okay, next one up. So this protected executive privilege is that the White House can refuse to provide any information because someday something might be subject to a claim of executive privilege. Therefore, there's no room for negotiating with Congress. It's like saying that we're not making a formal claim of executive privilege. This doesn't count as an invocation of executive privilege but you can't have the information anyway because someday it might be subject to a claim of executive privilege. Well, think about just how broad that is, how much that writes Congress and congressional investigations completely out of the equation in our system of separated powers. So this is a way I argue of putting a legalistic sounding phrase around a practice of refusing testimony or documents just on the basis that they might be subject to a claim of executive privilege. Bad precedents make, bad future practices. And in my research, I found some documents from the Clinton administration in which the Attorney General defined the contours of the executive privilege principle, and they articulated a concept called subject to a claim of executive privilege, which is another way of withholding information without making a formal claim. And actually, the Trump administration has cited this document as a basis for its protective executive privilege. Okay, next one. So, as the others have said, the courts generally don't like to get involved in resolving executive privilege disputes. Back when I first wrote about this in the early 90s, and a lot has changed since then, revising this book has taken quite a lot of work. I think there was a certain understanding of the parameters of the scope and limits of this power, and that there was an accommodation process between the political branches that generally worked quite well, and that the courts did not have to be regularly getting involved in these disputes. And I argue that's the way the system should work. There's a kind of constitutional gray area with regard to executive privilege where I've said it would be a terrible idea to put a legislative definition around it or legislative imposed restraints, or to have continual court cases in which the principle of executive privilege is continually narrowed down in very sort of technical legalistic ways. I think that there is a necessity to having a certain flexibility with regard to the exercise of this authority, but that implies a certain trust that presidents will exercise this authority judiciously, and that the president and Congress will engage in a good faith negotiating process in order to resolve these issues in a way that meets the needs of both branches. And really the system, I think, for most of our history worked really, really well. That's not happening today. And that's a very, very big problem. So what happens when the executive outright rejects the legitimacy of countervailing powers, such as the power to investigate, which is going on right now? So I close my book arguing that the traditional tools that are at Congress's disposal to force compliance with congressional demands for information were sufficient, and therefore we don't need further legislative definition of executive privilege or further judicial definition of the concept and limitation of the scope and parameters of that power. But the traditional way of doing this doesn't seem to be working quite so well. We've entered into a kind of zero-sum battle environment now that's pushing these issues out into the courts, where I think it's not the best place to be fixing these disputes between the branches. So I close with the question, will the courts continually want to get involved in these disputes, or tell the other branches, don't come to us to fix your disputes, try to find a way to work them out on your own. So I will stop there. Thank you for listening.
Thank you, Mark, very much. And now for a last case to talk about, another one that is, I believe right now, pending before the Supreme Court on a stay. Is that right, Ashwin?
That's right.
If you could talk about the case involving the Mueller grand jury documents.
Yep, I'll talk very quickly about this one. It's a little bit of a kind of an odd duck that it doesn't sort of deal with the typical issues having to do with oversight, but it is an important case that is currently pending before the Supreme Court. The Justice Department filed a petition for certiorari, I believe, last Monday, I believe. And so, so this is pending before the Supreme Court. It basically deals with the portions of the Mueller report that were redacted as grand jury materials. And so there's a federal rule of criminal procedure, Rule 6E, that allows district courts to release grand jury materials that ordinarily should be kept secret in certain situations. And one of those situations is preliminarily to a judicial proceeding. And so this case raises the question about whether an impeachment proceeding in the House and then a removal trial in the Senate, whether any part of that or all of that constitute a judicial proceeding under Rule 6E, such that a district court can release redacted portions of the Mueller report that concern grand jury materials to the House so that they can view those portions of the Mueller report that they still haven't seen now more than a year after that report was released. This is a question that the Supreme Court has never addressed. However, a number of lower courts have held that Congress can receive grand jury materials when it's relevant to an impeachment proceeding. And in fact, the Department of Justice itself in the past agreed with that position, or at least consented to the release of documents in a variety of different circumstances. Grand jury documents were sent to the House during sort of preliminarily to the impeachment of President Nixon. There have been a couple of federal judges in the last couple decades that have been impeached where they first, their conduct was first sent to a grand jury, and then those materials were forwarded to the House of Representatives with the Department of Justice's consent. But they have taken the position in this case that a judicial proceeding does not include an impeachment proceeding because a judicial proceeding requires sort of a typical court with a judge, what you might think of as like an Article 3 court. So this case was brought by the House to try to get these materials. A district court in DC said that they could get them. The DC Circuit agreed in a divided opinion. Interestingly, Judge Griffith, who was was nominated to the DC Circuit by President George W. Bush, and who in the McGahn case didn't support the House in that case. Did support the House in this case and held that the committee should be able to get these materials. And the case is now stayed pending Supreme Court review. And I'll just say one more thing about the case, which is, and I think this has been sort of a trend in a lot of these oversight cases, timing is everything. And the difficulty with this case now is that it comes to the Supreme Court at the very end of this term. If they did grant it under the ordinary course, this case would go on the fall docket, be heard in November or December, and then potentially decided in spring of 2021. The issue with that is that Congress only has a 2-year term. So at the end of this year, this Congress is done. Its investigations end, its subpoenas expire, and a whole new Congress is sworn in next January that sort of has to start from scratch. That doesn't mean that these documents wouldn't be useless to a new Congress, but of course there's going to be an election this fall as well, and so they may sort of become moot because they require these documents to know whether or not to have another impeachment proceeding, basically, of the president. That's the reason they're requesting these documents having to do with the president's conduct detailed in the Mueller report. And so this case could quickly become, moot, essentially. And I think that's a pretty serious issue. And this also comes up in the McGahn case, relatedly. The DC Circuit is currently hasn't even issued its en banc decision. Presumably, if the administration loses, they'll file a cert petition in that case as well. And these cases were brought last summer, and now we're coming up on a year. And I think it's a real problem if you're somebody that wants the House to be able to see these documents. That the administration has sort of been able to run out the clock a little bit, given how slow, as it were, our judicial process works, and these cases have moved. And so I do hope if the court takes this case that they really need to expedite it, or they'll effectively be deciding the case by putting it on its regular schedule in the fall.
Thank you, Ashwin. And that's actually a great point, I think, about the timing that links up to Mark's point about courts and the extent to which they're involved, which is, to what extent is it actually a functional means of resolution? There are some Congress scholars. Josh Chafis is the one who's coming most to mind, who urged the Congress to go back to its own independent enforcement and send out the sergeant of arms to detain witnesses who will not produce documents, which would end up in the courts anyway with habeas, but might have a faster edge or might have addressing some of those speed issues. I want to give you guys a chance to comment if you have any. You've done a nice job of interweaving it into the discussion on each other's presentations, but there's one issue in particular that I would like to hear a little bit more about, because I think it's one where there's a bit of disagreement between Mark and Nick, and that's on this idea of absolute or testimonial privilege. And my question is, I guess, what's the difference, what's the practical difference between that kind of claim and a claim you're there and you assert no executive privilege on this point, executive privilege on this point, executive privilege on this point? And so I'm curious about what's the difference in terms of the burden on the sort of White House officials, or what kinds of protections is it that absolute immunity gives that the other, just asserting executive privilege in a hearing, isn't able to do? Because I don't think anyone disputes that there are claims of executive privilege that could easily be asserted by some of these officials who are so close to the president. Let me turn then that, so maybe Nick or Mark or.
Yeah, I'll take a first crack at it. I mean, so I think a couple of points. One is, I do think that what I find most compelling as a matter of practice is that even there's an intrusion in having Congress able to hail, a very, very kind of, what they sometimes refer as elbow staff of the president up before them, and kind of force them to go through the process of preparing to be interviewed or a hearing, to have a public airing where you have to assert those privileges, which I think has for a lot of the reasons that Mark articulated, I think quite well, a kind of optical downside that it looks like you're not being, you're hiding things, and you are to some extent, but it's a more challenging way to do that in a really public forum. And that's, I think the best arguments for it is that there is the question of whether there should be some small group that is given particular protection. Obviously, they can still choose to testify, and the president can still choose not to assert the immunity, but that it puts them in a different way, where again, you can't, put differently, there are protections that are availed of the legislative branch. You can't, have a senator's chief of staff brought to the White House to be questioned. There can be a little bit of asymmetry. Obviously, it's not on all fours because the White House doesn't have investigative powers, but I think that's the best argument for it. But I also think that it's a strongly held view of the Department of Justice. I don't think there's a ton of case law support for it, which is why it's not done very well in the courts thus far.
Mark?
Yeah, I don't think we're that far apart, actually. There is no absolute immunity to testimony for high-level White House officials, right? If there are credible allegations of wrongdoing that go to the highest levels of the executive branch, clearly there is precedent, and there have been presidential aides who have gone to Capitol Hill and testified. President Ford once testified himself, when there are allegations that he traded a pardon for the presidency, right? I don't see that there's any absolute immunity, but there are certain protections that should be in place for presidential advisors, right? So that presidents can get completely candid advice and not fear that every utterance is open to public disclosure that can be used against an administration. It really, it has to be reviewed on a case-by-case basis. There are no principles that articulate in every single circumstance exactly what the right outcome should be. So sometimes these things are just subject to the normal give and take between the branches and the negotiating process that goes on between them. And certainly there are some bad actors on both sides in this system, right? Presidents who may withhold information that's politically embarrassing, that has nothing to do with national security or protecting the public interest, or members of Congress on a fishing expedition who are just trying to bring down an administration, and they don't really have any good cause for seeking access to testimony or documents.
We actually have a question on the Q&A that relates to this, so let me go ahead and ask that. And it relates to sort of drilling down a little bit on instances of absolute immunity. So the question is whether anyone on the panel think it could be asserted, that kind of absolute immunity could be asserted if a high-ranking White House advisor was claimed to be a fact witness to wrongdoing. So, for example, if the advisor saw the president committing murder or taking a bribe, can immunity be asserted then? And also, can it be asserted in an impeachment proceeding?
So on the first question, even in this most robust iterations, it's only an absolute immunity to congressional testimony. So I mean, it is very much rooted in separation of powers concerns in that respect as well. That it's the co-equal branches is compelling the testimony, so it would not apply to a grand jury subpoena or other investigative processes. And I think that, to Mark's point, I think it's a much more difficult argument if you have to look at the nature of the inquiry each time, and it's a much more difficult argument that if it's an investigation into a specific wrongdoing and you're looking for someone to give facts. That being said, that is what I think the Judiciary Committee would, appropriately argue that is what's happening with McGahn. McGahn was a very central figure in the Mueller report, and had they made clear that they want to ask him very specifically about conversations with the president and others that they think are critical to the whole issue of obstruction.
Thanks for that, Nick. So I'm moving on to some of the other questions here, and again, another one rings true to me in terms of a question I had. In listening to the arguments at the court in particular, and you see it also in the U.S. government's brief and in Trump's attorney's brief, a real skepticism about the congressional side of the power, the congressional investigatory power, and an effort to read it quite narrowly, and an emphasis on the idea that it's an implied power and therefore should be read narrowly. So Ashwin, I wanted to turn to you on that and to connect it to this question. And the questioner expresses some amazement that the Congressional Oversight power, which can be inferred from half a dozen places in Article 1 and Article 2, and yet it seems on such tenuous ground, whereas we take it as an article of faith that the president's removal power, or as we've talked about, executive privilege, right, are implied, and no one necessarily seems to think that that's a reason to view them narrowly, or certainly not the people who are arguing for the narrow view of congressional power. So I'm just curious, is this a kind of imbalance that is of lengthy historical derivation? Has it been there all along? Is it more of a recent development reflecting perhaps greater assertions of executive power in recent years, or how do you understand that imbalance in the kind of arguments that are made?
Well, yeah, it's certainly a good observation. I think it's come up. It certainly came up in the president's brief and in the Justice Department's brief in Mazars multiple times. They sort of refer to this power as implied, and therefore that it, you need some kind of special justification or something like that. And that really goes against literally centuries of history. Even before the republic was formed, state legislatures as well as the British Parliament conducted robust investigations and had the power to call for papers and testimony. In the very first administration, I talked about this earlier, President Washington, the Congress investigated this particular military defeat, and while President Washington certainly said that there were limits to what the executive branch can turn over, he ended up cooperating with that investigation and turning over, basically, I believe that he turned over everything that they asked for in that particular investigation. And the president himself has been investigated for wrongdoing quite early in the republic. And so, I think the questioner is quite right that there are a number of different powers that are quote unquote implied in the Constitution in the strict sense that they're not written out specifically in words, but implied seems to have some kind of pejorative meaning when it's brought up in this context. And I think that's just that just really misunderstands how deeply embedded the investigative power is in this country's history and in Congress's, in Congress's conduct over the last, more than 200 years. And it makes sense as a logical matter too. I mean, when, Congress can't pass legislation without knowing what's going on, without knowing what the problems are in the world, without understanding what they can solve and how to solve it. Legislation is complicated. It's difficult. It's not an easy business, and it doesn't always, work out great, but it works out better when Congress knows what's going on. And so the notion that Congress could legislate without any information, without any ability to require people to come before it and tell them, what the problems are out there in the world and how they can solve them, whether it's banking practices or conflicts of interest or any other issue that they have, it really doesn't make much sense and would make the Congress, far less effective than it is with investigation. So I think it really is kind of, it flows logically from having legislative power.
Yeah.
And Mark, let me turn to you. Yeah, thanks.
Yeah. Oh, I just wanted to throw one quick question out to Ashwin, because on the first slide that went up, I was intrigued. It was that I tried to write this down quickly, whether subpoenas are reasonably related to an investigation in an area where legislation could be had. And the question I had was, can you just put a period after the word investigation and just get rid of in an area where legislation could be had? In other words, why was it necessary to add those words?
Well, I think that, well, a couple points in response to that. I mean, first of all, obviously that's the way the Supreme Court has enunciated the test, but I think the reason is because that's specifically where the power is derived from. I mean, that when we say it's an implied power, it's implied because of Congress's power to legislate. And I think that also, might be of some, that might, soothe some folks that might think, well, this power might be unlimited in some way. That's sort of a useful way to say, okay, no, there are limits. Congress, to the extent that Congress literally can't legislate in a particular area, they can't just go on fishing expeditions and investigate in those areas. There needs to be some basis for an investigation that can tie to one of its functions. And of course, Congress, to be clear, can investigate for other legitimate constitutional purposes like impeachment. But legislation tends to be legislation tends to be the reason that Congress is investigating, and is the vast majority of what Congress does.
Yeah. I just wasn't sure that you intended to put that constraint, that limitation there as an absolute one.
I see. Yeah, no, I guess I put it there because that was the basis for the Mazars and Deutsche Bank cases. And those are legislative investigations. But yes, certainly Congress can investigate for any constitutional function that it can carry out.
I want to actually pursue this just a little bit more. It also relates to another question we got. And I should say that I actually filed a brief with some separation of powers professors arguing much more for Congress has a legitimate oversight power, and that trying to tie it too much to some form of actual legislation is too constriving of Congress. On the other hand, and I think you alluded to this, Ashwin, and I'm curious about also what Mark and Nick think about, if you look at the range of subpoenas in the Mazars and Deutsche Bank cases, there is an aspect to, I'll put it in the most kind of controversial way I can, there's an aspect of fishing expedition to the financial services, one where they're using the president as a case study for financial malpractice in the financial services industry. One really does ask why exactly the president, even if it's our president with all of his undisclosed conflicts. So this led to the question, and the question that we have is whether or not there's some concerns about pretext here, and whether or not, in particular, in those cases, Roberts might be willing to entertain the same kind of pretext idea that was that he invoked in the census case here, to suggest that some of these subpoenas, at least, might just be a pretextual way of trying to get the president's tax records for the sake of getting them and exposing, which is something the court in the past has suggested is problematic. So I'm wondering whether or not you guys think there's any role for a pretextual inquiry here, whether or not it's important to draw distinctions between the different subpoenas that are at issue in these cases to try and come up with a more nuanced understanding, or in fact, are all of them within Congress's power? And this was an issue, just to close, this was an issue that I think the attorney for the House was really pushed on at the Supreme Court argument of what exactly are the limits, and how can we be assured that this won't be used as a mechanism for harassing the president?
I can maybe jump in first, but I'll go kind of quickly because I've already talked about this case a lot. So I don't think anybody disagrees with the notion that there may be some political motivations involved with issuing these subpoenas. I can't imagine that anybody could, with a straight face, say that politics don't come into play with everything that Congress does, and certainly when Congress is investigating the president. But at the same time, I think it's worth highlighting how truly unprecedented some of the actions of this president are when it comes to his finances, his financial arrangements, and the fact that he hasn't divested or put his assets in a blind trust. When it comes to the Finance Committee's investigation in particular, there really is a very substantial factual backdrop that led to these subpoenas. They aren't sort of, I think it really would be wrong to call them fishing expeditions. It may well be a case study in the sense that other people could also be violating the nation's banking laws or sort of pushing the lines when it comes to those laws. But to suggest that it's purely a fishing expedition really ignores the many, many contacts that this president has with Russian oligarchs and quite frankly, that Deutsche Bank has with Russian interests. And then, of course, the connection between Deutsche Bank and President Trump. He has all kinds of debts. Senior officials at, not to get too into the weeds on this, but senior officials at Deutsche Bank, it's come out, had serious concerns with the debts that they were holding for the president. So there really is quite a substantial factual predicate for these subpoenas. And so, is there some case we could concoct where really, truly an investigation is purely political, completely pretextual, and there's no legitimate legislative inquiry happening? Maybe that's right, but that really is not the case here by any stretch. And the court has said that where Congress can
let me just turn to Mark and Nick on that. So what do you guys think?
I'm curious for Mark's observation on the history here, but I think one of the things that has jumped out at me about this is that it really hasn't been where the action has been on the kind of litigation and in the courts in the post Nixon. I think whatever putting aside the merits of the argument, it's a fairly novel argument to focus the attention on congressional limits on the congressional oversight power and frankly kind of pretext. And it was not, I think if you look back to really across the presidents post-Nixon, it's not how it's been argued. I think generally people have assumed that Congress has an oversight, has a power. We do. I think the legislative interest is something that is something that's been brought up, and sometimes the role I think that's served has not been to question the authority, but to pin down the notion of what is the investigation about, because that can be pretty critical to how you think about privilege, and this is more in the document context often, to privilege and relevance and things like that. And so it would be something you would ask and try to get a congressional committee to identify what is your legislative interest, what are you focused on here. But it is something that I don't think has been the focus of the way White House acted. And when you look back through OLC opinions, it's not an area where the opinions where that does a lot of work. In my view, I'm curious if Mark or Ashwin have different views on that.
Mark?
I don't have different views. I think that's right, what both Ashwin and Nick said. Where administrations have acted badly in the recent past, it's been, claiming executive privilege in cases where they're trying to delay actions that could lead to, release of information that in some way would be damaging to the interests of the administration. And some have been very successful at dragging out the process and running out the clock on the administration, right? Think of the attorneys firings case in the Bush administration or Fast and Furious in the Obama administration. If they can use executive privilege in some cases as the first step in a multi-step process to try to negotiate out, a favorable situation for themselves from which they eventually back off, or they just, up the ante in the conflict in order to try to run out the clock on the administration. These are some of the games that are going on right now. But I agree. None of the case law, none of the claims post Nixon, I think, are about delegitimizing Congress's actual investigatory power and right to get access to information and testimony. And like I said before, I think almost all administrations have operated within an accepted constitutional framework that respects the bounds of legislative powers, with some exceptions, but the Trump administration claims have taken it sort of to the next level, right? In saying that the Congress basically has no legitimacy at all to be asking what they're asking or get the information that they're requesting. And I guess they're willing to take this into the courts and hope for a favorable outcome, which, who knows, might set a really bad precedent for the exercise of executive privilege and for principles of separation of powers in the future. That's my fear, how this all turns out eventually.
Right. It's interesting. So when you talk about negotiations and how these have been worked out before, and I think at least two of you, and I don't know about you, Mark, have had experience with the internal executive branch assessment of these kinds of questions. And some of the questions we've gotten sort of turn on what's happening with OLC, what's happening with the Department of Justice. I think one could also say, what about White House counsel? Because one thing that you would hope for is that executive branch lawyers would be seeking to do that negotiation to try and balance the concerns with protecting the presidency and the executive branch's legitimate functional needs and claims of stature and protection against what are also quite legitimate needs by Congress and on the other side. And yet it seems like part of the breakdown may have been that we're not seeing that. So I'm curious about whether or not what you guys think is happening on the executive branch lawyering front of this, and whether or not in the past actually executive branch lawyers have been able to play a more meaningful role. Is that one thing that has changed with the Trump administration, is that we don't have those voices that are either being listened to or that are there to make more nuanced points?
Just very quickly, I'll say something maybe controversial. OLC attorneys write self-serving pro-executive branch arguments. And then future administrations refer to those memos as though it's established constitutional law. It isn't.
That might actually be heresy for some people, I'm just saying.
Too bad. It's, I'm right.
I would say that OLC. I think. Look, I think at the first point, just procedurally, OLC has a critical role in most of these issues, even from the White House perspective. So you before you assert an executive privilege, make a formal executive privilege claim, there is an underlying OLC memo that goes with it. Similarly, for testimony immunity, you have an underlying OLC memo. And I think historically that has been an important aspect. I do think it is fair to say that OLC has had a robust view of the prerogatives of the Department of Justice and has not been afraid to take views that are based on OLC precedent being as important as at least some level of judicial opinions. I think one of the other things that will change a lot with this is I don't think that's true of Supreme Court opinions, but I don't think that OLC has, I won't make Ashwin respond to this, but I don't think OLC has always necessarily had the view that a district court opinion upends a well-reasoned OLC opinion, which is based on usually DC Circuit and Supreme Court law. So I think that has been a really important check, and I think it's a fair observation that it's what the role, what OLC's role in some of this is an open question. I also think there are folks at the current Trump White House who served in the Bush administration. And I think, I certainly think some of the arguments they're making are ones that were not made in that in the second Bush administration that were not made. And I don't know how much of that is a question of different views on the law, or also I do think there's been a change in how some of this is consumed publicly, where the kind of, I also think one of the kind of unspoken parts of this is, I think, to go back to where Mark was, I think there was always a view that there was a huge downside and barrier that was felt by any executive branch for protecting documents against an investigation, that kind of idea of a cover-up was a really problematic thing to walk into, and that was a risk if you turned away requests for immunity, especially if it's well predicated on, if you turned away requests for interviews or requests for documents, especially if there's a strong factual predicate, that you look like you're covering up some real wrongdoing. And I just think that hasn't seemed to have the same salience in the last couple of years that it's had previously. And I don't know if that's because of, the current political climate or what, but I think that will be I think that had real impact on how folks made decisions around this stuff in the past.
I'll just add one thing, which is, obviously OLC generally takes a pretty strong view of executive power, and I think has been relatively consistent on that front in some areas. I mean, absolute immunity, absolute testimonial immunity is a good example. Like, that has been an OLC position for a little bit of time now, even if its origins might be a little bit murky. But I think what's a little bit worrying about OLC and the Justice Department a little more generally with regard to these oversight cases is that in some other areas, they really have just kind of thrown out their prior position without really much fanfare. The Mueller report grand jury materials case is a really great example where the Justice Department was perfectly okay submitting materials to Congress until this administration suddenly has this problem with the grand jury materials in the Mueller report. And in the McGahn case, actually, that's also an interesting example of where OLC has changed its position. It's taken a fairly consistent view on absolute immunity more recently, but when it comes to the ability of courts to hear these kinds of disputes at all, actually OLC in the 1980s had the exact opposite position, where basically they said that the ordinary tools can't function in this area because typically when a person refuses to comply with a congressional subpoena, the executive branch prosecutes them under federal criminal law, but the executive branch isn't going to prosecute somebody in the executive branch who is, by order of the president, not refusing to comply with a subpoena. And in that situation, really, Congress's only the only way that Congress can enforce this type of subpoena is to go to court, unless it's using its own sergeant at arms and going and having some kind of battle with executive branch police officers or something. And so when that's really the only avenue that Congress can use to enforce its subpoenas, literally OLC in the 1980s, in a number of different opinions, one of which was signed by Bill Barr, I might add, said that Congress can go to court and enforce these subpoenas. And that has just been a complete 180 change of position in this administration. And I'd add also going back to the second Bush administration with the Myers case. So OLC has not been consistent on that issue, and those kinds of flips of positions, I think, really harm the legitimacy of that office.
And I think we have just 1 or 2 minutes left. And so I just want to flag that last point to get some words on it, because we did get a couple of questions about why is the congressional investigatory power considered implied given the necessary and proper clause, which is definitely, I think, a very good question to ask. And also, isn't it connected to appropriations and other powers? But then also this question of Congress's inherent contempt power. And my question, well, first of all, I'm curious about whether or not you think we would ever go back to a period in which Congress might actually exercise its contempt power and arrest if it in fact standing is denied. But even more than that, to what extent do you think the possibility of that might play into the way courts approach analyzing the standing and justiciability questions? That what we really don't want to have is an instance where we have the sergeant at arms going out and arresting because there aren't judicial and more legal avenues. Do you think that's going to play in at all, or is this really not an issue that's really directly in play? Anyone?
Well, I mean, one observation is that if what the court wants to do is to get out of these disputes, that the idea that's going to get them out of the dispute is, I think, fairly excited, right? I don't think, if I were a lawyer for someone who was arrested under inherent contempt, I think I'd be going to court pretty fast to work on that issue. So I don't know that there's an easy way out of a court's role in trying to navigate these by focusing on non-justiciability of this kind of a subpoena enforcement or a similar suit.
Yeah. Great.
And to the extent that this kind of avoidance is trying to avoid this kind of conflagration between the branches more generally, it's hard to think of a more sort of a hotter burning conflagration than what that would be. So
you mean the sergeant at arms appearing at the White House gates? Yeah. And on that note, I think we should end. Thank you all, Mark, Nick, and Ashwin. Thank you so much for such a great presentation. Really appreciate it. Thank you to our audience. And we will be doing another webinar, this one on the appointments cases, the Puerto Rican appointments case this term, and also the CFPB removal case in early July. So stay tuned for emails and notifications about that. Thank you guys again.
Thank you.
thanks so much.
Thanks, Julian.